Greetings, my fellow Americans, and welcome to another episode of the Great Montana Conspiracy Podcast. Tonight we're going to be talking about conviction integrity, and we're going to be talking a lot about conviction integrity units. Now I'm going to be using the abbreviation CIUs. But before we get started, if you happen to be watching this on YouTube, please like and subscribe, and for that matter, in any format you happen to be watching this, please do the same. Also, please share this video, social media, through your friends, whatever. Get the information out. The more people that are informed about this information, the more people that can act on it, the better we all are off. First, before I start talking about conviction integrity, I'd like to give you some really startling statistics. And I've gone over these statistics in the past in very different degrees as I've talked about wrongful convictions, but they are very, very critical. So I need to make a point of this right up front of the video. Between 2 and 10% of convicted individuals in U.S. prisons are innocent. It's not just maybe they might, I'm thinking it's far closer to 10% and probably higher than that. On a national scale, roughly 40% of prosecutions that are initiated in most jurisdictions don't follow through. They're prosecuted, they're exonerated, and they're freed. Not in Montana. It's far higher, closer to 99% of prosecutions. And I have said this in the past that I've never met a person who's been prosecuted who has been exonerated. Well, I do need to amend that statement a little bit because I have encountered people who have been prosecuted as leverage to get them to abandon legal claims, to get them to hurt other people. For instance, in my case, my ex-girlfriend, Mara Jafrida today, she was Mara Pelton then, was prosecuted to make sure she was intimidated and bar me access to our business assets, to give me access to money, resources, to be able to fight back against what they were doing. So, and her charge was dismissed just prior to my trial, so we could not bring that information into the trial. At least that's what my attorney said. We could have brought it in. He didn't want to. It was a deal he made with the prosecutor, essentially. If you drop this charge against her, we can't bring it in, and we won't bring it in. So they dropped it. We could have brought up the fact that she was under threat and she was only released from the threat, and I think it would have helped my case at the trial, but my attorney would not do it. Just like my attorney would not challenge whether my accused victim was actually lying or not. He refused to. He absolutely refused to. He said, we don't want her crying in front of the jury. No, but if we can prove that she's lying because she said this 5 or 6 different times in different capacities and changed her story multiple times, that's important. He refused to raise that issue in front of the jury. Refused. I argued with him vehemently on this issue. He refused. But that's just an example. I'll go into more information in a little bit, but remember, 2 to 10%, according to national statistics, various different degrees out there of reports and studies, have determined that somewhere between 2% and 10% of convicted individuals in the U.S. are actually innocent. Since 1989, 2,666 people have been exonerated in the U.S. That's just since we started recording that information, making it nationally available. Only 2,666 people. Only. There's millions of people in the criminal justice system in the U.S., and only 2,666 people have actually been exonerated. Proven innocent people have served more than 23,950 years in prison so far. Now keep in mind, it's important to emphasize that. Proven innocent people. There are many people who have actual innocence claims who can prove their innocence, who are denied actual innocence claims, denied the ability, or have gone beyond their appellate period, beyond their ability to challenge their conviction. So there are many people out there whose cases are proven innocent. Either the true culprit is caught, or somebody else comes up with a different suspect, or any number of situations and circumstances where an actual person who's convicted is proven innocent but cannot overturn his conviction. Welcome to the American legal system. Out of every 100 people sentenced to death in the U.S., 4 are likely innocent, but only 2 get exonerated. That means, people, ladies and gentlemen, people who are killed, put to death, and yes, in the United States we still have this barbaric practice called the death penalty. And yes, I say it's barbaric because there is no taking that back. Once you take someone's life, if they are innocent, you cannot take that back. You cannot undo a death penalty. When someone dies, there's no taking it back. If you kill an innocent man or woman, you cannot reverse that. That's why it's barbaric. You can't take a death penalty and impose it upon someone unless you are absolutely 150% sure they committed the crime. If there's any measure of doubt, they maintain their innocence. They were proven guilty, but they've never confessed. Circumstances, DNA, whatever circumstances are out there. I know of cases that I've read of where people who have been killed by the death penalty before the introduction of DNA have gone back retroactively and proven, wait a minute, DNA doesn't add up, they didn't commit the murder. But they're still dead. 69% of wrongful conviction cases happen due to eyewitness misidentification. Someone thinks they see someone, they think this person is the person, and they're so intent upon making sure a guilty person pays for it, they will set aside their individual doubts of whether it's the person they saw, or they may actually genuinely believe it's the person they saw. Or it may just be somebody hears a scream down an alley, they look down the alley, and this other person's running, they see that person running, they don't realize this person might be looking for the culprit. They might be running because they don't want to be, caught at a scene of a crime. Any number of things. They may not have actually committed the crime, but they were just seen as the scene. False confessions account for 29% of wrongful convictions. And this, again, are proven wrongful convictions. Not just the ones that people insist they were coerced. These are just the people whose convictions have been overturned. Official misconduct plays a part in 31% of murder exonerations. Official misconduct. I remind you of Brad Helios' case. Just did a podcast on that a couple weeks ago. We just had this issue where none of the evidence added up to first-degree murder. They pursued it anyway. Official misconduct. They went out in the community. They spread this false information. They spread hearsay evidence through the paper, through the media, through social media. The family was out there doing their best. The officials did nothing to quell them or silence them or put a gag order on them. Any of these powers could have worked to stop that negative influence, and the corrupt officials simply allowed it to happen because they were more interested in convicting someone, anyone, for anything to advance their own political careers. False accusations are present in 70% of wrong convictions. 70% of overturned convictions are from wrongful convictions. And that means 30% are procedural or circumstantial, or this process was involved, that right wasn't honored, or whatever. But 70% of false accusations are present in 70% of wrongful convictions. 70% false accusation. Sound familiar? I've maintained my innocence now for over 18 years over a false accusation. And yet I have so many people dead set on wearing me down and insulting me and degrading me and doing their level best to defame me because I have the audacity to stand up and say, I didn't do it. It was a false accusation. 70% of wrongful convictions result in false accusations. According to William Blackstone in 1769, he had a very famous quote. He said, "The law holds that it is better that 10 guilty persons escape than that one innocent suffer." And of course, he's referring to convictions. In other words, Blackstone said it was better that 10 guilty persons get away with their crime than one innocent person get convicted. Benjamin Franklin took it a step further. He said, quote, it is better that 100 guilty persons should escape than one innocent person should suffer. He compounded it by 10. I would go as far as say it's never okay for a single innocent person to be convicted. Ever. It's never okay to punish someone for something they didn't do. Never. It's never okay to do that. My entire life has been obliterated because I was accused of something I didn't do. Not because they actually believed this crime was committed, because they were trying to protect themselves from a lawsuit. The corrupt officials of Flathead County were more concerned with protecting themselves from their own misconduct than they were in whether I actually committed a crime. In 1895, the Supreme Court went even further back in history for a doctrine that supposedly comes from the Roman law, and that says, it is better to let the crime of a guilty person go unpunished than to condemn the innocent. That, right there, is the standard by which we should all be living. It's the foundation of our country. It's doctrinated in writings of Thomas Jefferson, Benjamin Franklin. It's written into every procedural subject and discussion from our founders. When it's talking about the justice system, it's always about protecting the innocent from harm, not having such an overzealous criminal system that innocent people are thrown just to make sure you get one guilty person in the mix. We call that collateral damage if it happens, hey, you go into a war zone and you shoot the bad guys, an innocent person gets shot, it's collateral damage. Well, that's a war zone. That's heat of the moment. Not that it's always excusable just to blindly shoot into a crowd. But can you imagine? This is a court of law. It takes months to process, sometimes years to process. This isn't heat of the moment. There's no justification for collateral damage. The zealousy of the individuals prosecuting these cases cannot be the dominating factor here, and yet it is, because they don't care. Whichever doctrine you go by, it is a founding principle of our country. The idea that it is better to have a guilty person go free than an innocent person be convicted is foundational. Honestly, if a single innocent person is condemned, it's a travesty of justice. It's a travesty, period. To have an innocent person's life upended, thrown into prison, having especially in the modern day of information, having their name blacklisted across the country for the rest of their lives for something they didn't do. I'm not just speaking about myself. There are thousands, if not millions of people out in our country right now who succumb to this so-called criminal justice system. And I've talked ad nauseum about the idea of over-criminalizing our justice system, making money off the justice system, the prison for profit system that exists in our country, where the federal government passes money down to make sure that the states and the local levels have money to keep people incarcerated so they can keep putting people in jail and keep putting people in prison and start lining people's pockets. But as I've mentioned, projections right now suggest at least 1 in 10 in prison could be innocent. And sadly, this is just based on the numbers of people who have succeeded. And of course, to succeed, you first must make an effort to try to assert your innocence. I spent 5 years and change in lockup between the 20 months I spent in county jail, the rest of the 5 years in prison, and then the couple of months I spent in jail when they tried to revoke me for the first time. The second time they tried to revoke me, I was out in a couple of days. But the first time I spent a couple of months back in jail. So I spent 5 years and change incarcerated within the lockup system. I have personally seen people I know with beyond a shadow of a doubt are innocent, who are forced to take plea bargains every single day. And I've talked about this before, about how people, they have to get back home to their works, they have to get back home to save their families, they have to get home to save their jobs, they have to get home, they cannot stay incarcerated. These are not people who are charged and then released back in the community while they're waiting a charge. These are people who are held under an excessively high bail, put into under $25,000, $50,000, $100,000 bails. Just sometimes $500 is too excessive if you have no income and you have no resources, or you live paycheck to paycheck, as so many people in our country do. They lock them up, they hold them until they break and say, I've got to get out, or I'm going to lose my home, I'm going to lose all my property, I'm going to lose my family, my children, my job, everything if I don't get out of jail. And so they will take a plea bargain. What people do not tell you about plea bargains is that one of the underlying aspects is they must waive their right to appeal. They cannot take the plea bargain if they do not forswear their constitutional right to appeal. So in other words, in order to take that plea deal, you have to agree you cannot challenge this later on down the line. You cannot get released, go back to your life, and then come back and challenge this conviction. It's set in stone. There are exceptions. Prosecutorial misrepresentation, something that's not, misconduct of some kind. But generally speaking, 99% of the time, these are locked in stone. They lose their right to go back and plead their innocence. So all of these statistics about overturned convictions or wrongful convictions do not reflect those who take plea deals. Those who are coerced into taking plea bargains forswear their right to appeal, forswear their right to come back and challenge whether they're innocent or not in most cases. And that means that's an entire group of people you're not even looking at in these statistics. Once they are coerced into a guilty plea, they do not get to come back and plead their innocence. They lose that right. They lose that capacity. Like I said, there are exceptions. But generally speaking, innocent people who take pleas, they lose the ability to assert their innocence, and they cannot get their convictions overturned. Another factor not considered by these statistics, especially in Flathead County, where people are held under criminally high bails, unconstitutionally high bails. Remember, the 8th Amendment of the U.S. Constitution says no excessive bails. Right there. $10,000 to somebody who may not even earn that much in a year is excessive. $25,000, $100,000. Like I said, in many cases where people live paycheck to paycheck, they literally get their paycheck and they spend it within days. And when they spend it within days, they have no choice but to say, I can't raise $500. They may not have real estate, they may not have property, they may not have anything. But what they have is the ability to say, I give up. I give up. Do whatever you want to do, but I've got to get out. I can't stay here. I can't stay locked up. That kind of coercion, that breaks people. They just lose the will to keep fighting. When seen from the position of being helpless and powerless, people lose hope. People stop fighting. Even arguably, especially if they are innocent. People who are guilty and are trying to take a stance of innocence tend to fight to preserve that innocence because they're trying to maintain their criminal lifestyle, because if they make the fall, then that criminal lifestyle goes on their record. Innocent people who are just, they don't know what to do, they're helpless. They aren't criminally minded, they aren't deceptive, they aren't deceitful, they just, what can I do? They lose their capacity to fight. They get worn down. I can tell you from personal experience, when I was inside, I was trying to do mental exercises because I was losing my ability to focus. I was losing my ability to even recall details. I remember going over Magic the Gathering sets, in my mind, trying to remember. I had these memorized back of my hand. I could recite them with my eyes closed, the exact order they came out in, because it was my job. I dealt with them every single day. But within a couple of months, I was losing those details. I would sit down and try to recall the sets, just as a mental exercise, and I would forget. There'd be sets I can't remember their names. Long-term incarceration leads to brain function diminishment. It just does, because there's nothing to keep your mind engaged. There's nothing to, it's just, you get up, you have breakfast, you might watch TV, you have lunch, you might watch TV some more, and you lay back down and go back to bed. It's completely just boredom. There's nothing mentally stimulating. You can, there's books in a book rack. If you lucky to get a book to read that you can find an interest and engage in, you might be able to read a book. But it doesn't challenge you. It doesn't. You lose your mental acuity incarcerated, and you start losing your willpower. You start losing hope. You get depressed, and there's no treatment for that. There's no, well, let's see. Are you possibly feeling depressed and overwhelmed by your circumstances? Of course they don't. They want you to feel overwhelmed and depressed by your circumstances. That's the whole point of keeping you in there. Otherwise, they'd release you and wait for your bail, or wait for your hearing and forget about bail. But consequently, as a result of all of this, these statistics don't even begin to reflect the true number of innocent people incarcerated, who are convicted wrongfully, who are innocent of their crimes. I remember one circumstance, and just a story that comes to mind. There was a guy I was in jail with, and he was just going through a divorce. He was going through a divorce, and his wife decided to assert that he had molested his daughters. The wife would not allow the children to be subjected to medical examinations, so they could not verify whether any molestation had ever happened. But after a while, he just said, you know what, I just can't live in this box. I can't live not having fresh air. I cannot live. I've just got to, I'll do it. I'll say whatever they have to say because I need to get out of here. I just can't continue to live here. His whole identity was falling apart. His sense of self was falling apart. So he took a plea deal just to get out. And I remember him talking about, he's like, well, what do I say? You know, when I go in front of the, because you have to take a sentencing hearing and you have to go in front of the judge and tell him why you commit the crime and everything else. And he was trying to find ways. I'm not going to sit here and say I did this. I'm pleading guilty. But how can I get on the stand and lie? And I remember his lawyer's advice, I think, was what he ended up, it was not at the hearing, obviously. But as I recall from his conversation, the lawyer's advice was, like what I was accused of. Like what I was accused of. What did you do? Like what I was accused of. Because he didn't want to sit there and detail something he didn't do. But that's how the system wears you down. This is how innocent people fall. And once you take that plea bargain, you're done. You can't go back. You can't proceed with innocence. You can't challenge it. So these wrongful conviction numbers don't even begin to reflect. And remember, over 90% of cases in the United States are settled through plea bargains every year. That's 90% of the conviction population out there that aren't even reviewed for whether they're false convictions or whether they're truly innocent. Because once they take that plea bargain, they're guilty. There's no going back on that. According to statistics from an agency called the Montana State Council and Forum on Judicial Accountability, there are 67 offices around the country in the United States who have set up what are called conviction integrity units. District attorney offices are basically going back and looking at old convictions and saying and determining whether or not the person actually is genuinely innocent, falsely convicted. Only 67 offices in the entire United States. The entire United States. Remember, there's 50 states. So that's barely an average, barely a tick above an @1 per state average. And I guarantee every state doesn't have them. Montana does not have any that I've been able to find. There's been a couple of calls for them, but Montana does not have any conviction integrity units. And right now, according to national statistics, and again, this is coming from the Montana State Council and Forum on Judicial Accountability, Montana ranks 9th in judicial exoneration. So we're 9th highest. Honestly, I think if you actually had criminal investigating units here, we'd be a lot higher. But they have a mission statement supporting this action in Montana on their website. And I'll provide a link in my description for this video because I really think it's important to look at it. And I don't want to sit here and read it verbatim, but it's incredibly detailed. It's encapsulating. It brings up a lot of good points. And they're not the only agency calling for criminal investigation units. ACLU has called for CIUs on a national level. The Innocence Project here in Montana submitted a proposal to the Montana legislature in 2016. Of course, the Montana legislature has ignored it. They have not done anything with it, but it's on the Montana legislature's website. That particular report from the Innocence Project cited Kings County DA's office conviction review unit as a national standard. And yeah, and I actually visited their website and looked at their program and everything else. And they do in fact have an independent post-conviction justice bureau, and of which the conviction review unit is actually under that banner. Their website states they are the first standalone bureau in the nation, and I cannot find any information that contradicts that. The problem is, in my honest opinion, the review criteria that they set out is too narrow. It doesn't encapsulate everyone, it encapsulates specific cases. Rather than openly reviewing claims of innocence or a sampling or just reviewing every case that comes down the line, first the person must meet a pre-screening criteria for review. Unless they are deemed credible through this pre-screening process, the claims are disregarded. So someone can come forward and say, I'm innocent. I didn't do it. And if the review unit, the criminal investigation unit says, or the conviction integrity unit, says we can't find any initial evidence of pre-screening of anything done wrong, therefore their claim is disregarded. They don't even go beyond the pre-screening process. They don't re-interview witnesses, they don't go back to the evidence, they don't go back to the record, nothing. They just, on an overview, do we deem the plea of innocence to be credible? And if they don't, it's disregarded. And I imagine that probably has to do, in a lot of cases, as to whether the person's taking a plea bargain or not. If they're taking a plea bargain, I imagine the very fact that they got on a stand and pled guilty precludes them from this kind of review. Also, to review evidence, they only review evidence. They don't review the procedural issues. For instance, in my case, Lori Adams, now a city municipal judge, who was at the time deputy prosecutor, deputy county attorney, went into the courtroom, the clerk's office, at 4:33 in the morning and filed false documents between 4:33 and 4:44, according to the AM, according to the court stamp. And we have a machine that sits on the table that you punch it in. It's a clock. It's a punch clock, just like if you go to a job and you punch your clock. It's the same kind of principle. It was clocked at 4:33 a.m. and 4:44 a.m. The warrants were then withheld from the court record. Only a holding document was kept there, so the case number would not be reassigned. She kept those documents on her desk until 4 days later when she found out, oh my gosh, they actually arrested him under the warrant. These are all procedural, criminally abusive fraud. The criminal investigation unit in New York would not be able to oversee this, because it's procedural issues. It's not dealing with the evidence. It's not dealing with the testimony. It's not dealing with any of that. All that would be precluded from examination by their criteria. My point is that all U.S. citizens are entitled to equal protection under the law. That's the 14th Amendment to the United States Constitution that says that. It says that everyone's entitled to equal protection under the law, and equal protection has been regularly redefined as equal access under the law. Which means every person who's convicted of a crime should have the right to have their case reviewed by this. It should be an option. You're convicted? Okay. Before we go any further, would you like to have your case reviewed by a CIU? Would you like to have it, the conviction integrity unit look over your case to determine whether or not, to determine whether this conviction is proper? It should be an automatic. It's not. All U.S. citizens should be entitled to a CIU services and not pre-screened, not predetermined whether or not you qualify for their search criteria or whatever criteria they're looking for. It should not be a conditional right. And it's not a right, it's just a convenience if they feel the deemed is necessary to look into. And it should not be limited to evidence provided by prosecution. I mean, that could already be tainted. It could already be manipulated. It could already be, the witnesses could already be terrorized, threatened, whatever. You can't rely on just that. You have to look at the whole circumstance, everything involved with the case. Now, as much as I agree and support this initiative, I 100% endorse the idea of bringing this legislation to the legislature and having them pass a mandatory conviction integrity unit process. I believe it is critical to go a step farther. Several steps further, probably, but at least a couple of steps further. In my personal experience, there is no true independence in Flagler County. Every single attorney here is complicit in the corruption that exists here. They're aware the judicial officials are corrupt, that they hold grudges, that if they do not comply with the whims and will of the judicial officers, that their cases will automatically rule against just out of spite. And therefore, they go along with it. They go along with the prosecution. They comply with the prosecution. They're worried about upsetting the prosecution. They're concerned about upsetting the prosecution because if the prosecution gets upset and the judge gets upset, then they don't win cases and they don't advance their own careers. There are people who literally been blacklisted in this county and cannot get a fair hearing for any client because they have snubbed their nose or stood up to powers that be in this county. In order to practice law in this county, you cannot be an independent. You must be complicit with what's going on, acknowledging it, aware of it, which means you're not going to be standing up to it. If you get appointed to a criminal investigation unit, or a criminal integrity unit, a conviction integrity unit, a CIU, you are not going to put your career on the line. If you've already been complicit, if you've already been kowtowing and bending the knee to this corrupt system, you're not going to start changing your integrity now. You're going to keep doing what keeps you in business. Which means if you have any kind of a conviction integrity unit in this county and it's associated with the practice of law and it's not independent in the civil community, there is absolutely no way to seat a fair and impartial administration in a conviction integrity unit. Not in Kalispell, Montana. It's not possible. I do not believe there's a single attorney in this county who has not complicitly bent the knee to this system and allowed it to happen. Otherwise, the Judicial Standards Commission would have thrown these judges off the benches years ago. We would not have the problems we have if there was a single attorney with integrity in this county. And I'm not talking about personally. Personally, I get along with a lot of these attorneys. I see them on the street, I talk to them, hey, how you doing? I get along with them. But they make allowances. They allow for, I had a conversation just with a private investigator who works for the attorneys here in this county. And I'm not going to mention names because I actually like him. He's a decent guy. But even he pointed out, I told him, I was talking to him about I was just talking about a few minutes ago about how the documents have been filed at 4:33 in the morning, at 4:44 in the morning, that Lori Adams had basically filed a false issue. I had been arrested even before there was a warrant filed in the docket, 4 days before there was a warrant filed in the court, because it was kept on Lori Adams' desk. It was never signed by a judge. A new warrant was issued a week later to make up for that deficiency, but I'd been in jail for a week at that point in time. And I told him, I said, based on just the very premise of the fruit of the poisonous tree doctrine, the conviction could not proceed on that fraudulent foundation. And his response was, well, even if you went back and overturned this conviction on those grounds, what's it even from rearresting you and recharging you? Not, well, yeah, we need to get you to do this and we need to fight you and prove it. It was immediately saying, well, what's the point? Because they're just going to do it again. They're going to rearrest you and put you back in jail because they can. There's nothing stopping them. And that's my point. There is no independence in this county. Even officials who work for attorneys are not fair. You have to have, just like I in my last podcast where I was calling for civil oversight, actually having members of the community oversee the police department. You can't have members of the judiciary or the prosecution's office or even the attorney field be part of this program. You can have an attorney be there for explaining the law, explaining the circumstances, explaining this and that, but at the end of the day, You have to be able to say, we cannot bring in people who've already been tainted by the corruption that's already here. This isn't a matter of preventing corruption. This is about the pre-existence of it. And there's no way to screen against it. Because no one is going to get in front of take an oath under penalty of perjury and say, yeah, I've committed all these crimes. First of all, Fifth Amendment privileges against self-incrimination stand out, but they're not going to openly admit to committing crimes. And I say openly because I remember this very last podcast we were talking about how Under Sheriff Du Bois was talking to County Attorney Honor and openly talking about how every person in Flathead County commits fraud. We backdate documents all the time. Everybody does it. But guess what? It's fraud. It's crime. It's criminal. And yet, nothing. Nothing. Because they are good buddies inside the good old boy system. But he's not going to openly get on the stand and say this. He's not going to openly get on the stand, because when the newspaper, the NBC Montana contacted him, his response was, it's not the routine practice to backdate documents. We only do that if it's necessary. He still couldn't help himself with saying, if it's necessary. It's never necessary to commit fraud. I said that last time, I'm saying it again. The idea here that officials in office, they bend to the superior's wishes. The attorneys bend to the will of the people, the judges, that they have to win the like of in order to have a fair chance for their clients. Regardless of the efficacy involved, they are complicit in this corruption. Any kind of a conviction integrity unit that was set up in this county and appointed and made a part of the county attorney's office or staffed by anybody in the legal field would be suspect, because they're going to advance the agendas and the curriculum of the powers that be, because if they do not, they obliterate their own careers. End of day, they're going to obliterate their own careers, because the people they're going up against are well entrenched. You've got to have people who don't have any kind of a loyalty, any kind of a conflict of interest, any kind of an attachment to the legal system, actually looking at these cases and making a credible decision. It needs to be civilian oversight. Must be civilian oversight. It cannot even be attorneys or people, families of attorneys, or people who work for attorneys, or anybody else who has a loyalty to the legal system, because the legal system is the problem. The legal system is what must be overlooked, overseen, and you can't do that if you're asking the foxes to guard against the foxes who are eating the chickens. It doesn't work that way. That's why you have dogs to chase off the foxes. You don't have foxes to chase off the foxes, because the foxes are just going to join in on the massacre of the chickens. And that's all that happens. The problem is that a CIU, a Conviction Integrity Unit, is attached to a prosecutor's office, like what we have in Kalispell. Any appointment to that agency is going to be cherry-picked by the prosecutor. There are only going to be people in that office who are not going to upset the apple cart. They're going to advance the prosecutors and the court's agendas. They're only going to rubber stamp official misconduct, just like we saw Du Bois do. I refer you to the story of Deputy Wendt. I just talked about it a minute ago, but let's, just for the purpose of anybody who has not seen that, let's give a very brief overview of that. I reported this in my last episode. A report was made of attempted insurance fraud by Deputy Wendt. The county attorney was informed, let the sheriff's office conduct its own investigation. The undersheriff, Wayne Du Bois, cleared his officer of wrongdoing. Rubber stamped it, said, no wrongdoing, no wrong, no foul. A reminder of the Friends episode where Joey and Phoebe are conducting a race between the chick and the duck, and they're looking for a nutter butter on the ground. And Joey, of course, is the judge, and he's participant, but he's the judge. And Joey puts his foot out and blocks. I think it was the duck he was blocking. And Phoebe's like, oh, foul, blocking, judge. And Joey says, judge ruling? No foul. And Phoebe goes, oh, you know, fair call. Clearly, Joey was not wanting to admit that he just blocked it. He's going to use his influence to basically make sure that his contestant wins. That's the problem we have when we have a corrupt system. Because the corruption will make sure the people who are appointed to oversee it are not going to be people who are actually invested in actually upturning or overturning convictions. I can guarantee you, if my case was before a I keep saying criminal, a conviction integrity unit established in Kalispell by the prosecutor's office, I guarantee no matter how much, and if you want to know how much volume of evidence is out there, read my book, U.S. Political Prisoners Since 2004. It's on Amazon. You know, you can get it. You can get it on Google for free. You can search for it. It's out there. Look at my book. Look at the evidence. There is such an overwhelming amount of evidence that says this was done wrong. So wrong. And yet, no matter how much evidence I produced, no matter how much I bring forth, I guarantee the prosecutor's office would not overturn my conviction. It would not find I was actually innocent, because it advances the agenda of the powers that be in the good old boy network to keep me incarcerated. Because while I'm incarcerated, they get to keep threatening me. They keep getting to silence me. I can't speak out. There's things I can't say. There's things I can't do. I can't even go on a national book tour to do book signings of my own books, much less the political prisoner book. I mean, I'm handcuffed in what I can do in so many different aspects. And as I've said before, for everything I am saying, there is so much I can't say. I'm forbidden to say it. I'm forbidden to talk about it. I'm forbidden to go places. I'm forbidden to do things. I'm forbidden, constantly in every corner of life. And so, and remember, I just applied for early release. I have 2 years left on my sentence. 2 years. And I was eligible under the new revision. It used to be you had to do 3/4 of your time. And then you could apply for early release. Or 2/3 of your time, and you could apply for early release. And they revised it, and it was 9 months. So with 2 years left on my time out of 20 years, I'm more than qualified. Or just 2 years left of 15 years of probation, if you want to look at it from that angle. Way more than qualified for early release. Judge Huddy Albright shot it down with the most ridiculously libelous order yet. She even cited a non-citable order to justify her position. She violated the standards of the state judiciary just to cement her position and say, I'm right, look, I'm right. Here's the Montana Supreme Court who agreed with me, and here's what they said. But they issued it as a non-citable order. Why? Because if they had issued it as a citable order, it would have overturned a dozen or more precedents in the state, because it did not comply or conform with any precedent of the state. It was uniquely unconstitutional. They knew it was. That's why they made it non-citable. And then she turns around and cites it to try to back up her position. Why go to such excessive means to keep me just for the last 2 years? 2 years out of 20 years. I'm not out breaking laws. I'm not out doing drugs. I'm following the rules of probation and parole, even though I don't agree with them. Why? Because they desperately don't want me out there. And I have said it from the very beginning. They're going to wait till the very end, and they're going to try to find a reason to revoke me and throw me back into prison for 15 more years and restart the clock. And they're going to keep doing it because they can. Because no one stops them. Object to it, cry about it, but you still elect these people into office. And when they get elected into office, they keep doing what they're doing. And in Flathead County, you don't even get a choice. No one runs against the person who's already in office. Nobody runs against the judge who's already there. Nobody runs against the county attorney. No one runs against the court clerk. Nobody runs against the incumbents. Because it's political suicide to do it. Because they have to put up their careers on the line. Because these people who are corrupt, who are in positions of power, remember, you have to be a judge, you have to be an attorney to be a judge, and you have to be practicing law in this jurisdiction, which means you still have to put your cases in front of that very judge you're running against. Or all his cronies, his fellow judges, who are part of the Good Old Boy Network, and they respond to the agenda of the head judge, they respond to the agenda of the Good Old Boy Network, whatever protects their own. So you're stuck with these people. When officials intent on hiding corruption in their offices are in charge, there will be no oversight. There will not be. It's impossible to happen. The presumption of any kind of a conviction integrity unit's independence rests upon the presumption of integrity. The officials in Flathead County have shown none. They openly discuss commissions of crimes by their subordinates. Once again, Wayne Du talking to County Attorney Honor, talking about how every person in Flathead County has backdated a document at one time or another. It's a regular occurrence. His people do it, your people do it, we all know we all do it. Why do they need to complain about this? It's not that big of a deal. They have a bulletproof mentality when it comes to accountability. They have no accountability. They are immune from prosecution. They are immune from consequences. They are immune from drug abuse. They are immune from fraud. They are immune from intimidations, threats, outright murder. They can kill somebody and get away with it, and they know it. If corrupt officials set up a conviction integrity unit, it would purely exist for a show. It would be all about smoke and mirrors. We've put up we're now being responsible. We're being diligent in making sure that our conviction. No, they're just going to use it to rubber stamp everything. They're not going to use it to actually overturn convictions. They're not interested in overturning convictions. They don't want to, because in Montana, your entire political career rests upon your jacket of successful convictions. You don't want your convictions overturned. Why would you want that? Why would the county attorney's office want to do that? Because they don't care. They've never cared. If they cared, I would not still be here. I would not be here. And I'll say this about Travis Honor. And this is not, I don't know the man. I will say this about him. And you can quote me. He had the opportunity to jump into the pond, into the swamp, and try to take me down when I filed this motion. His office chose not to respond. Now, mind you, they didn't endorse it, they didn't acknowledge it, they didn't say, we agree Mr. Glick has served his time. But he chose not to get involved. I don't know if that speaks of integrity, because we're looking at the situation right here where he's dealing with Du Bois, and he doesn't do anything to Du Bois. He doesn't do anything to his deputy. But I gotta say, say one good thing about someone, and I always try to be as fair and equal level playing field as I possibly can. He had the opportunity. His office chose not to address this issue. Left it entirely to Judge Albright, and then Judge Albright took up their argument for them. She threw away impartiality. She threw away any sense of integrity. Threw away the standards of law in the state of Montana to do what she did. But it was not because Travis Honor did anything to perpetuate it. That's the one thing I can say about Travis Honor that, like I said, you can quote me on it. I can't speak for him. I don't know him personally. I've never met the man. I've never even talked to him. But I'm telling you this one thing. He had the chance to get involved and he didn't. Dig for it as well. The only true independence for a conviction integrity unit, even if Travis Honor was running it, I'm sorry, but even if Travis Honor was running it, I do not have faith that it would be independent, and the truth would come out. I think he would be worried on some level about the county being sued. He has to defend the county against any lawsuits. A wrongful conviction, 18 years served on a false conviction that was maliciously perpetrated by corrupt officials and official misconduct. This is a massive prosecution. We're talking people who would go to prison if he did it right. For not getting involved, to saying he would actually proactively do the right thing is a big leap. Remember, his office could have endorsed my release. It could have come out and said, we think that Mr. Glick has served his time. He has been a notable member of the community. XYZ. They didn't. So I can't say that he would actually do the proactive thing. He chose not to get involved. It's not the same thing as saying he would be on my side or he would do the right thing. But anytime you have this kind of a setup, it has to be community-based. It cannot have any affiliation with government officials or attorneys. Attorneys would need to be present to explain the law, just like they would to a grand jury. But they should not be involved beyond that. Everything else about the Montana State Council and Forum on Judicial Accountability is right. I just defer on the formations of the CIUs. Their positions to petition for a legislature mandate is proper. It's the proper route. Petitioning for it, calling for it, yeah, absolutely. I agree with it 100%, and I 100% endorse the process. I do foresee a problem, because this is Montana. Corrupt officials do not willingly give away power. We saw this recently with when the Montana legislature sued the Montana Supreme Court, appealed the Montana Supreme Court's decision to the U.S. Supreme Court. We're going to end up in another in-government lobbying effort against any kind of a law like this. Just as a reminder, Montana Senate Bill 140 abolished the Judicial Nominations Commission in 2021, became law. Previously, prior to this, the state Supreme Court got to give a list of proposed names to the governor, and the governor had to select from that list of proposed names for judicial replacements of any vacancies in office around the state of Montana. Any district court position that became vacant, they would get to have the pre-selected list, give their selected list to the governor would select from that list. What the Montana Senate Bill 140 did is it abolished the Judicial Nominations Commission and gave all power to the governor. Now the governor gets to pick anybody he wants to sit in that position. Obviously they have to meet the criteria of law, presumably. They still have to be a lawyer. But he could appoint somebody from in his staff. He could appoint somebody who has a completely different record. He can actually advance jurists that actually have a better political stance to his own. And he's not limited to the small little group of people that the Supreme Court cherry picks. Surprise, surprise, this did not go over well. Head Supreme Court Justice Mike McGrath, his court administrator, and several district court judges were caught essentially lobbying across the state against this law, trying to influence that this law not get passed. They did so using state resources. That's criminal, by the way. They're not legally allowed to use state resources to lobby. If they were going to lobby against this, they had to do so in their own private time. They could not use the state servers. They could not use their state email addresses. They could not use their office hours. They could not represent themselves in their official capacity to do this, and yet these people were doing exactly that. The legislature went to investigate. They tried to subpoena the court administrator for her emails. Oh, sorry, don't have them, I deleted them. Once again, criminal. The law of Montana requires that all communications, emails be preserved. She just admitted that she committed a crime. No one's going to prosecute her, but she admitted it. So the legislature went to the executive branch and to the actual technologies department and actually subpoenaed it directly from them. They retain all records. So they got the records of the court administrator. The Montana Supreme Court flipped out. They said that the state legislature did not have the authority to, or a genuine legislative purpose in subpoenaing these emails. Essentially, something in those emails the Montana Supreme Court does not want made public. And I think it's probably a lot more than just this one lobbying issue, personally. But, nevertheless, they didn't want those emails to become public record. And if they went to the legislative record, they would become public record, potentially. So they issued an order revoking the subpoenas and ordered them to immediately return the emails. Montana Supreme Court legislature appealed the decision. Honestly, I think we're going to see a very similar situation. Not so much necessarily the subpoena power question, but the in-government lobbying that we saw with this particular. This is just the Supreme Court losing power, just over nominations. They were freaking out about that. Now imagine every single county attorney's office in the state being mandated to have a convictions integrity unit, have oversight independent of their agency, and be able to review the convictions that they obtain. If one agency in Montana started in-government lobbying, and of course brought in district court judges across the state to help them, do you honestly think we would not see a repeat of this from the county attorney level? Heck, from the state attorney general level, because state attorney generals are just as subject to this kind of review process as the counties. So yeah, guess what? We're going to get, even if this law makes it to the floor of the legislature, it's going to have huge lobbying against it from all corners of the state. I can't imagine a single county attorney's office in the state endorsing this, because Montana county attorneys don't want oversight. Judicial officers don't want oversight. Police departments don't want oversight. They don't want people telling them what they can and cannot do. And that alone should be an issue of concern. If you're doing nothing wrong, you should not be worried. I'm an open book. Someone asks me something, I say, here, look at this. I show people my wallet on a regular basis, show people what I have for cash. I don't care. People ask me for information. I give it to them. I don't hide information. I'm an open book. But when you go through a huge amount of effort to keep information hidden, that's a generally safe rule that you've got something to hide. And when you don't want oversight, that means you don't want to be caught doing something wrong. You should welcome oversight. You should welcome transparency, because it means you're doing things right. You're supposed to be representing the people, which means you should be subject to review by the people. And if you don't want review in any context, there's a problem. Consider that. If I don't want you to look in my bag, I probably have something in my bag I don't want you to see. Otherwise, it's open my bag. Here, take my bag. Look. Take a look. I don't care. Come to my apartment. Look around. I'm not doing anything wrong. Follow me around. I don't care. I'm not doing anything wrong. Look at my computer. Look at my internet activity. Look at my podcasts. Look at everything I'm doing. Look at my books. I'm literally open to any kind of inquiry, because I don't believe in deception. And I'm an open book. But when you have somebody who goes out of their way to fight this kind of thing, who will divert attention away by putting up a mock investigation whose only purpose is to rubber stamp whatever you want to be rubber stamped, there's a problem. You should welcome independent oversight. You should not question it. You should welcome it. And the very fact that Montana authorities fight this so vigorously says something in and of itself. No one in positions of power want oversight. It's just the way it is. The very reason I am where I am right now is because I sued to hold the police department accountable in Kalispell, Montana. They threw me into prison, and I am still their political prisoner to this day. I likely will be the political prisoner the rest of my life if they have their way. They don't have a reason to, other than the fact that they can oppress me, they can limit me, they can restrict me, and most importantly, they can penalize me if I overstep. And believe me, every time I put out one of these podcasts, I worry if I've gone too far. Is this the one that's going to get them to come after me again? Is this the one that's going to get them to make up a false charge and either arrest me on a brand new charge that doesn't exist, or for an action that doesn't exist, or are they going to try to revoke me and reinstate the 15 years under some made-up, atrocious nonsense? And yet here I am. I am here where I am because I stood up and tried to hold the police department accountable just in a lawsuit. Can you imagine being overseen by an entire department who looks at every single action you're taking, every single thing you're doing? We saw what happened when the legislature tried to take power away from the Supreme Court. Now imagine taking power away from every prosecutor in the state. Every single one. Bottom line is that internal accountability requires a pre-existing integrity. In my personal experience, unless a conviction integrity unit were established by an outside authority and manned by people outside the legal system, there's absolutely no incentive for corrupt officials to expose themselves. No incentive whatsoever. They know they are corrupt. They know they break the law. They don't care because they have no accountability. You ask them to suddenly hold themselves accountable, they're not going to go along with it quietly and meekly. They're going to throw a hissy fit, just like the Supreme Court did when it began losing its power. Much like outside community-based oversight of the police departments and the sheriff's departments, prosecutors and judges need to be independently scrutinized. They can't be scrutinized by their own. It doesn't work. It doesn't work when the pre-existing corruption is already there. It requires a pre-existing integrity that is not present in Montana. Prosecutions must be examined at all levels and should be by default. They don't have to be, it should not be applied for. It should be an automatic process. You've been convicted. Do you want to have your conviction looked at by the Conviction Integrity Unit to verify if it's an authentic and valid conviction? Before you're punished, before you're sent to prison, should the Conviction Integrity Unit not be involved? I mean, you can waive it. You can say, no, I'm happy with the deal I got. I just want to go to prison. But think of how many people would say, no, the only reason I pled guilty was because of this, that, or the other. I didn't do it. Remember, plea deals require forswearing the right to appeal. But if you have a conviction integrity unit that has the ability to pierce that veil, not be attached to the appellate process, should not be limited by the appellate bars that people sign agreements to. Maybe you'll just don't want to fight anymore. But if you have somebody sit down with them and actually empathize with them and say, look, I realize this is difficult. This is a conviction. This is this, that, the other. This is what we can do for you if you are interested. Are you interested? I would lay odds that a good number of people, probably 30% or more, would say, yes, please look at my case. If it was an independent agency, because also keep in mind, so long as that, if that conviction integrity unit is attached to the prosecutor's office, there's always a chance of retaliation. If they're aware of what the conviction integrity unit is doing, the prosecutor can always come back and retaliate with a new charge, give you a harsher sentencing, any number of things. They can arrest your family members, they can threaten and intimidate your family members or people who are close to you or witnesses in the case or whatever else they want to do to get you to not comply, to get you to give up on your claims of innocence. Because that's what they already are doing prior to your conviction. If they can keep doing it, because the conviction integrity unit is subject to their oversight, and therefore they are aware of who's involved and who's not, it becomes an issue. Must be separate. And one other thing, that's probably something that no other place I found online have said, but I personally believe this. A conviction integrity unit must have the ability to come in and examine cases pre-conviction. That means they shouldn't have to wait till after the person's convicted, after they have this slight against their record, after they've suffered the penalty of however long they've suffered, whether it be pretrial detention, going to prison, whatever. There are people who literally, in some cases, have to go through chemical castration for crimes they didn't commit. Chemical castration. There are people who are told they cannot be with their families. They are told they cannot hold certain jobs. They have to sell off their assets, personal properties, all as part of judgments. And believe me, if you have the ability to have a conviction integrity unit be able to come in advance and say, hey, what's going on with this case? If someone can go to them and say, look at my case, look at this situation, look at the circumstance, it's not flush, it's not right. Personally, I spent 16 months incarcerated in county jail waiting for a trial. 16 months while the prosecution and the police department, everybody was out threatening my ex-girlfriend, taking her children away, depriving her of their social contact, the family unit, destroying my reputation in the community, convincing everyone that the reason why I was still incarcerated was because I was guilty, even though I had not been convicted. The paper was running their fair share of articles, continuing to advance this idea that I was using my youth recreations program as some vile den of molesting children. All because I was held in detention for 16 months under a $50,000 bail I didn't have, because they arrested my girlfriend and said I could not liquidate deprived her of any contact with me, which is I couldn't liquidate my business assets, could not raise money for my own counsel, my own attorney, possibly even my own bail. Could not get out, could not do anything to aid in my own innocence. Because they wanted me there. They wanted me under their thumb for 16 months while they were trying to set up a trial. And even then, they had to get a jailhouse informant to say I confessed, who was conveniently dead a week later. 10 days after my trial, Frank Raymond Allen, who was the witness for the state who claimed I had confessed, was dead. No overturning his statement, no getting him to come back. It again is a story I need to bring in another time. If a conviction integrity unit could have independently examined the process early on, looked at the illegal filings, the 433, 444 AM filings, the warrant that never had a judge's signature, the new warrant was issued a week later after I was arrested. Questioning, if you just look at the very beginning, the foundation of the prosecution, I would not have spent 16 months in jail. I would not have been convicted. The case would have been thrown out. Any attempt to come back at me with a retaliatory prosecution, again, a conviction integrity unit could have looked at it and said, this is a vexatious prosecution, and thrown it out. So conviction integrity units need to be pre-existing entities as well, in order to be fair. Remember, the whole idea here is about not harming an innocent person. That's the actual language of the quotes. Harm. Not prosecution, not conviction, harm. When you lose your life, you lose your livelihood, you lose your family, your associations, your property, you are being harmed by a corrupt system that if you are innocent, you do not deserve. And I argue in many cases you don't deserve it even if you are guilty. But that's besides the point. The point is what we're talking about here are people who do not deserve to be in this process. And there is no system that is universally applied across the country that cares. We have 67 jurisdictions, 67 offices around the entire United States that have conviction integrity units. Nowhere are they mandatory. There is no single state where they are mandatory. None. They are voluntary organizations. And they are run by the agencies that voluntarily create them. Presumably and hopefully these organizations exist for the purposes for which they are set. But what's to keep a corrupt office that wants to just put up a conviction integrity unit for show? What's to keep that from forming? There's no way for me to sit here, trapped as I am in Montana, go around and interview all 67 units. There's not even one in Montana that I could interview. By the way, if there's anybody who knows of one who would like to have someone contact me, I would love to interview, talk to you, review your process. I would love to be a part of it, be able to come back and report it. Love to. So there's an invitation. I often extend these invitations out there. So far I haven't had anyone take the bite, but I would love it. Basically, you must be able, in a criminal justice system, if your purpose is to prevent innocent people from being harmed, you must have the ability to actually be proactively preventing that. That's what a conviction integrity unit is. As I said, right now they exist purely in the post-conviction capacity. I think they need to exist at all levels, because that's the way you prevent harm. Not after the harm is committed, before the harm can be committed. In a justice system supposedly founded on the principle of not harming innocence, why is this such a foreign concept? Why is it so hard to get people to understand or wrap their minds around this? If our premise and our foundation of our country is based on not harming innocents, letting 10 people, 100 people go who are guilty just so one innocent doesn't suffer. If that's the foundation, if that's the principle our founding fathers had in this country, why have we abandoned it? If we can spend massive amounts of money on incarceration, and once again, look to my prison for profit subjects in my other podcasts, if we can spend so much money on incarceration, billions of dollars on incarceration, why can we not spend an equal amount on conviction integrity? Why can we not spend an equal amount on making sure the people we actually convict are guilty? Because if there is an innocent person convicted, a single innocent person convicted, for whatever reason, harm is being done unjustly and inappropriately. And we should care about that as a country, as a people, and most importantly, in the Great Montana Conspiracy. Because the Great Montana Conspiracy is keeping this from happening here in Montana. As always, as I end these videos, I remind you once again, if you are watching this on YouTube, please like and subscribe. Share the video. Again, whatever platform you're watching this on, please do the same. If there's not a text attached to this video in detailing how you can support this program, please go to the origin source of this podcast, which is monspiracy.podbean.com. As always, please share. The more people that know, the more people that are informed, the more people that could actually possibly affect change. And as I end this podcast, as I always say, I hope everyone out there is being safe, and whenever possible, please be free. Thank you.